Imagine preparing for years for your dream exam, studying day and night, sacrificing your social life and putting everything on the line. Then just days before the results, you learn that the paper was leaked and the exam is cancelled. Your future is uncertain and the accused remain free for years. And in order to tackle this growing crisis, PM Narendra Modi has announced the creation of fast-track courts for paper leak cases. But will these courts finally put an end to India's paper leak mafia, or is this just another promise that won't solve the real problem? Well, let us understand the complete picture. Firstly, that why the government announced fast-track courts. Notably, on July 23, that is yesterday, Prime Minister Narendra Modi announced that the government would push for fast-track courts in order to ensure quicker punishment in paper leak cases. A proposal is set to be placed before the cabinet, followed by a bill in parliament. And at the same time, the Delhi High Court has also established a special fast-track court in order to hear the ongoing paper leak case. The announcement comes in the wake of the NEET UG 2026 paper leak, which sparked nationwide protest and raised serious questions about the credibility of India's examination system. Well, what is the shocking reality of the paper leak cases? Let us highlight about it. The numbers reveal just how deep the problem runs. Between 2002 and 2025, India witnessed 45 major paper leak incidents involving examinations with over 1 lakh candidates each. And all these included 27 recruitment exams and 18 school, college and university entrance exams. And during this period, 1,658 people were arrested and 925 charge sheets were filed. And yet, despite all these investigations, only 18 people have been convicted, and that too in just 2 cases. One case involved the 2002 Railway Recruitment Assistant Station Master exam, where 8 officials were finally convicted in 2025, more than 2 decades after the paper leak. And another was the 2010 Railway Recruitment Board leak, in which 10 people received 5-year prison sentences in 2024. However, many of those convicted later secured bail, and the biggest question still remains. If justice takes decades, can it really deter criminals? Well, what happened in the NEET 2026 case? Let us shed light on that now. The NEET UG 2026 examination conducted on May 3 was cancelled after investigators uncovered a major paper leak, and the investigation is currently being carried out by the CBI, Rajasthan Special Operations Group and State Police. And so far, 13 people have been arrested, including 2 experts associated with the NTA's paper setting committee. The examination was conducted again under strict security on June 21, and the results have already been declared. And the case is now being heard in Delhi's Rouse Avenue Court, where the accused remain in judicial custody as the CBI continues its investigation. The controversy had a devastating human impact, and reports also suggest that 22 students lost their lives before the re-examination, highlighting the immense mental and emotional pressure that such incidents place on aspirants. Does India already have a law against paper leaks? Well, yes, but only recently. Until June 2024, India had no dedicated central law to deal with paper leaks, and authorities relied mainly on IPC provisions that is related to cheating, conspiracy and forgery. And following the NEET and UGC NET controversies in 2024, Parliament enacted the Public Examinations, that is Prevention of Unfair Means Act 2024. The law makes offences like paper leaks, tampering with computer systems, stealing OMR sheets, creating fake exam websites, and helping candidates cheat non-bailable offences. The punishment ranges from 3 to 5 years in prison with fines up to ₹10 lakh, while institutions or agencies found guilty can face 3 to 10 years of imprisonment and fines up to ₹1 crore. However, legal experts argue that stronger laws alone cannot guarantee faster justice. Will fast-track courts solve the problem? Experts believe that there are 3 major challenges. First, fast-track courts are controlled by state governments and high courts, not directly by the central government, and their functioning depends largely on state-level decisions. Second, simply creating a fast-track court doesn't guarantee speedy justice, and trials still depends on quality investigations, evidence, witness testimony, and court infrastructure. And the third, the Supreme Court has repeatedly warned that justice should not be rushed. A speedy trial is important, but fairness cannot be compromised. Poor investigations or hurried proceedings can lead to wrongful acquittals or convictions. So how effective are existing fast-track courts? Well, India already has two kinds of fast-track courts: regular fast-track courts, that is FTCs, and fast-track special courts, that is FTSCs, which mainly handle cases involving sexual offences under the POCSO Act, that is POCSO Act. While these courts dispose of cases faster than regular courts, they continue to face an enormous backlog. And despite disposing of over 3.3 lakh cases, millions of cases are still pending across the nation, and this shows that fast-track courts certainly help, but they cannot solve systematic issues on their own. So fast-track courts are undoubtedly a positive step, but they are not a magic solution. And in order to truly eliminate paper leaks, India needs stronger investigations, secure examination systems, quicker charge sheets, better cybersecurity, and strict accountability within the examination agencies. And only when these reforms work together with speedy courts can the country restore the trust of millions of students. So what do you think? Will fast-track courts finally end India's paper leak crisis, or does the system need much deeper reforms? Let us know your opinion in the comment section below, and do not forget to like, share and subscribe to the Savera for more updates.